Hello and welcome back to the another episode of the Hindu News Analysis. Well, the date is 6th November 2025, and in this video we are going to discuss some important articles which are very much relevant for your preparation. But before we'll start our discussion, I would like to give you the basic idea what our approach would be while discussing these articles. So first, with respect to every article, what we are going to do, we'll try to understand the summary of the article. Here we will try to understand what this article is all about, why this article is here, and how it is relevant for your preparation. Second, we'll look into the key points of the articles which were raised by the author here. These key points are very much important for you because from here you can quote these points in your exams, or a direct prelims question can be asked from these key points. Then the third, we will look into the what could be the possible prelims or mains question which can be framed from this article. So possible prelims and mains question, we will look into that what can be framed from these articles which we have to discuss here. Now without any delay, let us start our discussion by looking at the first article as given in here. As you can see here on the screen, the article here discusses about the contempt of court in India. So basically here there is a story about what contributes to the contempt of court, how it is different, what are the criticisms to the contempt of court. Everything we will discuss here because it is directly related to your Indian polity. With respect to this, again here I would like to raise a point. If you want to know about Indian polity and if you want to get prepared for the Indian polity, we had already uploaded 30 lectures, 31 lectures for Indian polity, only for Indian polity, and we had discussed everything in a very brief manner, in a very comprehensive way. We had discussed every concept there. So if you want to get the knowledge, if you want to get the coaching of Indian polity, then you can visit our YouTube channel. There you can see the playlist and you can get all the information whatever would be required for you to clear the exam. So here with respect to this, as the article talks about the contempt of court, so it is very much important for us to know what are the powers of the Supreme Court, how Supreme Court acts or the High Court, how they act as the court of record, and how Article 129 talks about that. We will discuss that in a brief time. So first we'll look into the key points which were raised here and discuss them. So here, constitutional and legal basis. Constitutional provisions, Article 19.2 allows contempt of court as a ground for imposing reasonable restriction on fundamental freedoms. So as we discussed when we were discussing the fundamental rights, we discussed Article 19 in great detail. I guess we took one lecture for Article 1, it's Article 19 itself while discussing that. And if you want to get to know more about that, you can search it on my YouTube channel. That lecture would be available. But here, Article 19 talks about the freedoms given to us. For example, freedom of expression, how we have various freedoms, all are given there, and those freedoms, they are not universal, they are not absolute, but they come up with some restrictions, and one of the restriction to that is the contempt of court. We had discussed that, and for your information right now, that much is given in here. Then court of record, we discussed the Supreme Court and the High Court in great detail. We discussed the higher judiciary. There we discussed that the Supreme Court under Article 129 and High Court under Article 215 are designated as court of records, giving them the inherent power to punish for their contempt. So it is the Supreme Court and High Court, how they act as the court of record under Article 129 and 215 itself, and how under these articles they have this inherent power which we can induce that they can punish for their own contempt. Then we have the separate law, which is the Contempt of Court Act 1971, which further classifies the contempt, what kinds of contempt are, whether it is the civil contempt or whether it is the criminal contempt. It is further classified under the Contempt of Court Act 1971. So let's move forward and let's try to understand what is the definition of civil contempt and the criminal contempt. Civil contempt given in section 2b, it talks about willful disobedience to any judgment, order or writ, or willful breach of an undertaking. So it is the willful disobedience to any judgment. This will contribute to the civil contempt. Then what is the criminal contempt? It is publication or doing any act that scandalizes or lowers the authority of any court, prejudices or interferes with the judicial proceedings, or interferes with administration of justice in any other manner. So these are the definitions given under section 2b and section 2c of the Contempt of Court Act 1971, which defines civil contempt as it is the willful disobedience, and criminal contempt it is this scandalizing or lowering the authority of any court. So from here we had got the basic understanding of it as per the article. Now moving forward, what does the article further talk about? It initiations and limitations. Initiation: courts may initiate proceedings suo motu on their own if they will feel that anybody has done any contempt, or third party petition requires consent from the attorney general. For example, if I want to file a petition in the court with respect to the contempt of court done by anybody, any individual, for that first I will have to get the consent from the attorney general for the Supreme Court, or the advocate general for the High Court. So please remember that such statements can be asked in the prelims exam. Then what is the mode of criticism? Limitation: no contempt. Fair criticism of a decided case is not contempt. For example, if there would be any case and you are not happy with the judgment, for example, I would like to raise the example of the Article 370 when it was abolished and when the case went to the Supreme Court, and the question was asked there that whether we can diminish a state into a UT. Is it violation of federalism? Or then if it is violation of federalism, definitely, as the states or the federal part of the it is the federal part of our constitution, then does it violate the basic structure? For this the courts answered that right now it is not the permanent solution for the Jammu and Kashmir, and they will again go back to the statehood. But if the government further does it for some other state, then they will interfere in it. So this judgment you can criticize. There can be a fair criticism and it will not come into the contempt. This is what this statement here talks about. Is contempt what leads to contempt? Criticism that transgresses the limits of fair commentary or involves abusive language is considered criminal contempt. For example, if you would try to abuse some judge there, or you would tell, for example, you would make a statement that all the higher judges are corrupt or something like that, then it will it will add to the criminal contempt. Then what can be the caution? The power must be exercised with caution, and only when there is a clear violation, then only it should be exercised. There should be a clear distinction between what leads to the contempt and what does not lead to the contempt. This is exactly what the author here highlights. Then the purpose and warning. Purpose: the very purpose to punish for contempt is ensure the administration of justice. To ensure the administration of justice. This is the purpose why we need the contempt here. And warning: misrepresentation or attacks on the judiciary are detrimental to democratic principles and the delivery of substantive justice. So if there is the misrepresentation, if we are attacking the judiciary, and if we are making such statements which can influence the people, that their trust on the judiciary will reduce, so then it is very much harmful for the democracy of the country. So that is the purpose why there should be the contempt whenever it is necessary. Now moving forward here, with this we had understood the contempt, what is the purpose of the contempt, how it is initiated, how for example, if I have to file the contempt against any person whom I had to approach, and how the courts have the suo motu over it. So with this, I hope you had understood every aspect which was discussed in the article here. If you want to understand further more about it, I would recommend you guys to go to my playlist. There would be Indian polity, a separate playlist for that, and you can search there where we had discussed the Supreme Court, where we had discussed higher judiciary. Definitely you can find it there. With this, let's move to the type of question which can be framed from the article. Let's have a look at it. Here the question says, with reference to the contempt of court in India, consider the following statements. First, the power to punish for contempt is an inherent constitutional provision vested in the Supreme Court and High Court under Article 129 and 215, respectively. That is exactly correct, and that's exactly what we discussed. So when the first statement is correct, we can easily eliminate option C because there is no first statement. Now, the second statement, civil contempt includes the publication of any matter that scandalizes. You would had heard this word with respect to the criminal content. So definitely this statement is incorrect. It is not the civil, it is the criminal content. So we can eliminate option 2 here. We can eliminate option 2 here. So we are only left with option A. That would be the correct answer. And that's exactly what the correct answer to this question is. Now the third statement, for the sake of discussion, we will try to solve it. A private individual seeking to initiate contempt proceedings in the Supreme Court must first obtain the consent of the Chief Justice of India. No, it is totally incorrect. We saw that it is the Attorney General of India. So, with this, I hope you had understood the question here, you had understood the article here, and everything is sorted. Now, let's move to the another article and try to understand what it is about. Well, it is the conference of parties, with respect to the climate change, which is going to be held in the Brazil, and this is the conference while we will discuss, which is going to play a huge important role with respect to the climate change. The different approaches, how world has brought in different approaches, but all are just talks, and the real result is not evident. So this conference of party, which is going to be held in Brazil, it is named as movement of truth, where we will analyze what is going to be the real result, how the world has contributed, and how are the countries dealing with it. So with respect to this, let's first move to the key points, try to analyze it. Here, core vision and call to action. The COP of truth. The summit aims to be a movement of effective action and contact with the reality of climate change, especially in the Amazon rainforest. So this is the first thing what it talks about. What is the historical context? The world returns to Brazil 33 years after the 1992 Earth Summit, which adopted the conventions on climate change, biodiversity, and desertification. Now, here the article further talks about the Brazil's progress. Brazil has already halved deforestation in the Amazon in just 2 years, demonstrating the concrete climate action is possible. Now, further, climate justice and finance, common but differentiated principle, responsibilities. We had discussed this many times here itself on this platform. What is this common but differentiated principles? That how the global north, especially the first world countries, how they had already contributed to it. And now, if right now we will calculate it by how the developed or developing countries are contributing to the climate change, so it would not be justice with them. So it should be the common but differentiated responsibilities, how they should also contribute equally, and they should help the developing countries. In a nutshell, we had discussed this principle many times. The principle remains the non-negotiable foundation of any climate pact. Then justice, not charity. The global south demands greater access to resources, arguing that rich countries which benefited most from the carbon-based economy must honor their debts and rise to their responsibilities. That is exactly what comes under the common but differentiated responsibilities. Now moving forward, forest preservation and new mechanism, tropical forest forever facility. You please know that what this TFF is, a new innovative initiative to be launched in Belém mechanism. It operates as an investment fund, not a donation mechanism, rewarding those who keep their forests standing. Then investment, Brazil announces a 1 billion investment in the tropical forest forever facility. This can be asked in your prelims. Then fossil fuel transition. The article stresses the need to redirect revenues from oil products production to finance a just energy transition. It foresees oil companies like Petrobras transforming into energy companies, as the fossil fuel based growth model is unsustainable. That is exactly what is known to everybody. Now, moving forward, new climate pledges and targets, ambitious nationally determined contributions. Brazil became the second country to present a new nationally determined contribution. Commitment to reduce its emissions by 59 to 67% by 2023 to 2035. covering all greenhouse gases and all sectors of the economy. Energy mix: Brazil's energy matrix is among the cleanest, with 88% of electricity coming from the renewable sources. Call to others: all countries are called upon to present equally ambitious NDCs and implement them effectively. Moving forward, here we have a reform of global governance. UN Climate Change Council. Brazil will advocate for the creation of the UN Climate Change Council linked to the General Assembly. Purpose: this new governance structure would have the force and legitimacy to ensure countries deliver on their promises and reverse the current paralysis of the multilateral system, similar to the Security Council's failure to prevent wars. You know, that is very well known fact which we had discussed many times. Social justice: a declaration on hunger, poverty, and climate will be launched, recognizing that the most vulnerable are hardest hit by climate change and that the fight against global warming must be linked to the fight against hunger. So, definitely, it is also the necessity of the time. Now, moving forward, what kind of question we can expect from the exam from this topic? With reference to the recent climate initiatives discussed in the Balaam Summit preparatory meeting, consider the following statements. The Tropical Forest Forever facility is designed to operate as an investment fund to reward forest protection rather than a traditional grant or donation mechanism. That's exactly true. Second statement: Brazil's updated national determined contribution includes a commitment to achieve 100%. That's incorrect. Second statement is incorrect. We can eliminate option B and option D. What is the third statement? The principle of common but differentiated responsibility forms the non negotiable foundation of the call for climate finance for the global south. That is true. So, with respect to this question, the correct statement is statement 1 and statement 3. And from the code given below, the correct code would be option C. With this, let's move to the another slide and see what we have to discuss here. Well, it talks about the deaths due to road accidents. You know, in India we have record 400 deaths every day, and the article highlights that if we will calculate it in a way, it would be equal to crashing of an intercontinental flight, where 400 people will die every day because of the road accidents. And the article here talks about it is not always the human error. This is the negligence from money authorities, for example, those who grant the licenses and the infrastructure we have, and not proper following of the signals. All that when contribute together, it leads to it. So this is in a nutshell what the article here talks about. Now let's move to the key points and see one by one and analyze that. The scale of the crisis: frequency accidents are far too routine, exemplified by the two-wheeler accident that killed 19 people recently in Andhra Pradesh. Fatalities: over 400 people die on India's roads daily, mostly poorer folk, pedestrians, bus riders, and two-wheeler motorists. Systemic failure: unlike flight disaster, road deaths invite only perfunctory probes and glacial change in rules. So there is no much deep analysis is done when there are such road accidents. We will just conclude what are the reasons rather than going into the depth. Then moving forward, deep rooted causes: infrastructural failure, road defects, potholes, dangerous curves, and lack of essential safety measures like dividers, street lights, signage, crash barriers, and energy absorbers. Then neglect: national highway often fails to adhere to Indian road roads Congress guidelines, and states fail to maintain necessary safety rules required by the Motor Vehicle Act. These are the possible reasons. Then driver and licensing system failure: deficient tests, driving tests, or mere skill tests, ignoring knowledge of safe driving, and execution of practices like avoiding tailgating and arbitrary lane changes. Then corruption: the system of certifying and monitoring drivers and vehicles is described as broken and corrupt. Solution proposed: the Save Life Foundation advocates for transparent digitalized license seva kendriyas. Now moving forward with this article: accident patterns and emergency gaps. Common accidents: most accidents are collisions from the back or head on collisions, indicating wrong side driving and poor drivers. trauma care deficit in cities such as Bihar, fertility rates are double due to the inadequate trauma care infrastructure and lack of immediate treatment facilities, which is a major factor post crash. Technological gap, collision risk warning devices, though relatively inexpensive, are not mandated on commercial vehicles. Moving forward, here with this, I hope you had understood the article. Now, what kind of question we can expect in the exam? Here, the question says India's chronic record of road accident fatalities necessitates an urgent shift from a system that attributes most accidents to human error to one that fundamentally addresses systematic failure in infrastructure and enforcement. Analyze the four pillars of global road safety engineering, enforcement, education, and emergency care, and discuss specific actionable reforms required in India's driver licensing mechanism and highway safety protocols to ensure compliance with their Indian roads Congress guidelines. So, if you want to get your answer checked, so please do mail your answer to me at salvation UPSC 136 at the rate gmail.com. I will definitely check your answer there. Now with this, let's move to the another article and let's try to analyze it, what it is about. Well, it is related to your art and culture. A question from here you can expect. It is about the Sikh relic brought to Patna from Delhi after over 300 years. So let's jump to the key points here. The holy relic and its significance. Relic, the sacred Jor Sahib footwear. It is the sacred footwear associated Gurus Shri Guru Gobind Singh Ji Maharaj, 10th Sikh Guru, and his wife Mata Sahib Kaur Ji. So it is associated with these two great men and women. This with them. Spiritual importance, considered an important holy relic related to the Sikh faith. Custodianship, the relics were in the possession of private custodians related to Union Minister Hardeep Singh Puri's family, who offered them to the larger Sikh congregation. congregation. Then moving forward, the journey and the new location journey, the Jor Sahib traveled 1500 kilometers from New Delhi. Establishment date November 1. New location Takhat Shri Harminder Ji Patna Sahib, which is the birthplace of Shri Guru Gobind Singh Ji. So please remember this. You can expect a question from here. Duration of separation, the relic was separated from Patna Sahib for more than 3,300 years. Now, validation and provenance. Scientific validation. The relics were scientifically validated by the Indira Gandhi National Center for the Arts. Authentication. The provenance origin history was authenticated by the Union Ministry of Culture via carbon dating. And here, what kind of question we can expect? Here, the question says, which of the following place is historically significant for being the birthplace of the 10th Sikh Guru, Shri Guru Gobind Singh Ji Maharaj? It is definitely Patna Sahib. So with this, we had completed our today's discussion. I hope you would have liked the video. I hope you would share it with your friends so that they may also get benefited from this. I hope you would definitely subscribe the channel. Thank you for staying with me. Thank you very much and have a nice day.